again, with a mindful eye to the time, I would like to briefly summarize my position, the position of my client.
Yes.
In closing, the appellants argued that the proposed duty of care between commercial hosts and third parties who are not users of the highway should not be established. The appellants assert that the proposed duty does not fall within, nor is it analogous to, any previously established duty of care. By undertaking a complete ANS analysis, the appellants argue that there is insufficient proximity to establish a prima facie duty of care. Furthermore, even if a prima facie duty of care were established, it is argued that policy considerations would negative that prima facie duty of care. For these reasons, the appellants urge this court to grant an order varying the judgment of the Court of Appeal in British Columbia and negating the duty of care imposed on commercial hosts. Madam Justice Saron, Justice Smith, Justice Hackland, I thank you very much for your time.
Thank you very much. Yes, the respondents are ready to proceed.
Good evening, Justices. My name is Saron, and I am counsel for the respondent. I'd like to introduce my co-counsel, Ms. Leila Mustafi. I'm going to outline how we're going to proceed tonight. I'm going to recite to you 3 key facts. My co-counsel will address the first issue in this appeal to argue that there is no novel duty here. And then I will move on to the second and third issues in this appeal, which is concerned with the ANS analysis. So, 3 key facts. 1, the Commodore has a capacity of 900 patrons. 2, Mr. Donaldson and Mr. Briggs were patrons at this event. And 3, Mr. Donaldson left with other patrons that night and walked a short distance from the venue, the Commodore, at about 2 o'clock in the morning. And he was subsequently struck in the face with the glass mug that was given to Mr. Briggs by the appellants. So, having said that, I'm going to pass the floor over to my co-counsel to address the first issue.
Your Honors, the counsel for the respondent urges the court to uphold the judgment of the British Columbia Court of Appeal. The present case is analogous to an existing category of duty of care owed by commercial hosts to their patrons and third parties. Therefore, the application of the ANS test is not required. The Court of Appeal did not err in law in reaching the above stated conclusion because the appellant in this case, we submit, is a commercial host that benefits from selling of alcohol to the public. The commercial host is heavily regulated by liquor licensing. The commercial host has the ability to monitor alcohol consumption and sale. As such, the appellant owes a duty of care. Regulations impose responsibilities on those who profit from alcohol sale, and that the very existence of a licensing scheme indicates that there are special responsibilities afforded to commercial hosts. Appellants argue that this is a novel situation in which the ANS test should be applied. However, we draw the court's attention to the similarity of fact patterns between the present case and the previous ones, and the essential reasoning behind the general category of duty of care as owed by commercial hosts to their patrons and third parties. In Childs, Justice McLaughlin gave reasons as to when a case is novel, giving rise to a new duty. By looking at Justice McLaughlin's reasoning, it can be seen that the present case does not possess the novelty characteristics that Childs had. In Childs, this court, at paragraph 17, sets out 3 reasons for the novelty of that case as compared to Stewart and Petty. Quote, the situation of commercial hosts, however, differs from social hosts. As discussed in determining whether a duty of care arises, the focus is on the nature of the relationships between the parties. First, commercial hosts enjoy an important advantage over social hosts in their capacity to monitor alcohol consumption, as did the appellants.
If I may just interrupt you at one point, so I'm sure where you're going and that I understand where you're going. So you say this is not a new category. Would you define for me how you view the existing category? Is it commercial host vis-a-vis anyone, any patron?
Your Honor, we contend that commercial hosts in this situation, which is analogous to previous cases, are businesses that serve alcohol and profit from selling of alcohol, in that case, it gives them a special responsibility to take care because of the powerful incentive that exists in that situation for these businesses to oversell and overserve their customers. As such, there is a duty of care to take care of their patrons and third parties that come into contact with them.
So anyone, so the relationship we're talking about is commercial host vis-a-vis patrons first, and then anyone who could be in contact with those patrons following the drinking?
Your Honor, it could be third parties that could be adversely affected by the actions of their patrons. And if the court is drawing our attention to the fact that this category might be too wide, then I would say that in the later stages of finding liability, such as in standard of care, the category could be narrowed. But the essential reasoning behind the duty of care is the powerful incentive of commercial establishments to oversell alcohol and profit from that. And as such, the duty exists there.
Do you in fact make the bar or the establishment an insurer of anything that goes wrong? Is this what you're asking the court to do?
Your Honor, that is not what we're saying, and as this court has commented before, we are not asking for the court to eliminate all risks. We're asking for the court to recognize that this is an established category between a commercial host, as we have submitted, and their patrons, which are in fact both parties involved in this case are patrons, and the rubric of a third party may not even be used because Mr. Donaldson and Mr. Briggs were both patrons of Pacific Promotions and Commodore Ballroom, and they both were served alcohol at this event. And as my co-counsel pointed out, only short distance away from the event did this incident take place.
So what's the category now? Host vis-a-vis patrons who aren't too far away?
Yes. If I may reformulate that, commercial hosts that owe a duty to their patrons and third parties that could be adversely affected by intoxicated patrons.
There's a big difference. What about the patron who gets intoxicated, goes home, assaults his spouse? Does that fall in the category?
Your Honor, I think the facts in each case would be very important to look at. In that case, it would have to be seen whether the standard of care was met by that establishment, by the commercial host. And that would be the issue of that case. In this case, the issue is whether there is a duty of care that is owed by a commercial host, and we submit that there is. And the issue of standard of care and whether that was met or not would be at a later stage and not an issue before this court.
And standard of care would be resolved how? Saying that wasn't sufficiently foreseeable, or?
No, standard of your honor would be whether for example, the commercial host, which had the ability to monitor alcohol consumption, did in fact fulfill this duty, or whether they breached it. Do they have the necessary personnel, maybe the right amount of security? Maybe at the door they could have had the security that would keep a mindful eye for patrons that are over-intoxicated and could harm third parties as they're leaving the premises. May I proceed?
Yes.
Thank you. Third, the contractual relationship between a tavern keeper serving alcohol and a patron consuming it is fundamentally different from the range of different social relationships that can characterize private parties in non-commercial contexts. As stated by this court in Stewart, duty of care depends on the nature of relationship between the parties and not the minutiae of facts, as is being argued by the appellants. The present case does fall with a simple extension into an existing category of duty of care. In Childs, this court described 3 situations where duty of care has been recognized from precedent. The category similar and analogous to the present case is described at paragraph 37. Quote, where a defendant assumes a public role or benefits from offering a service to the public at large, special duties arise. The duty of a commercial host